Good evening, ladies and gentlemen. It's 5 p.m. This time on a Thursday. We had no chance to do it yesterday, so that's the reason why we are on a Thursday. So it's a little bit strange, but I guess everybody will work with it. We are in Berlin today. Mustafa Cakir is with me, and this is a live show, which means it would be wonderful when you have questions or comments what Mustafa is saying. So then it would be, or what I'm saying. So then it would be wonderful when you write it directly in the chat, and I will pick that up and integrate your questions to our discussion. So, what we want to discuss, you will learn about that. Mustafa is a guy for patent information, basically, and it is unbelievable what you can do with it from valuation. So, he wrote a wonderful blog post on the IP Business Academy, The Anatomy of a Valuable Patent. So, brilliant. He gave also a lecture. He's lecturer in our master program. Some weeks ago, he also participated there, and the students were fascinated from the lecture. So I'm very happy to have Mustafa here. Mustafa, my typical first question is, how did you came into that strange field of IP?
From the beginning of my life. Yeah, by chance, of course. As almost all of my colleagues are studying this patent business by chance. So it happened to me as well. In 2010, I started this patent business by chance by joining a pilot project which is managed by EPO. Thanks to my ex-director, Professor Fazilet Vardar, who was the director of my first technology transfer office in Turkey. And then she said that one day, hey, Mustafa, we have a very exciting project about patents, and which is managed by the European Patent Office. Do you want to join it? Do you want to manage this project? And I said that, what? What is the patents? I'm an industrial engineer. I don't have any idea about the patents in 2010. And then I started to look at the papers from the project proposal, which is written by our director. And then I checked all the work packages, and I said, yes, this is very exciting topic. So that's the moment that I started on patent business, because this pilot project, which is exactly about strategic use of patent information. And EPO gave us very comprehensive trainings in Vienna, in Munich, in different countries during the 3 years. And these 3 years, were the amazing time in my entire, in the beginning career of my patent business. And then I learned a lot from them. And then I started that business by giving this, patent search services. And then it became, more comprehensive day by day. But it is not all about the patent information. It's very comprehensive. I created my own package, niche in a niche, as you said that. And my expertise is focusing on only 3 topics. One is patent information, means that patent data analytics, creating some landscape reports, trend analysis. And the second one is patent valuation in terms of the financial valuation of the patents. And the third one is patent licensing strategies. Only 3 topics. So I'm a Turkish patent attorney as well, but I'm not doing any prosecution business. So that's the short story that I started on patent business.
Yeah, so funny enough that I started more or less in the same way. So I worked for the Fraunhofer Gesellschaft in Munich as during my physics study, and I made their patent retrieval. And so patent information was my starting point also. And I learned more and more what the whole thing means and how relevant it is. And it was simply the fascination of this intangible and intellectual property game, so to speak. And I switched immediately to valuation because in this there was an institute from the Fraunhofer Gesellschaft, which they have this MP3 thing that this big licensing game, and this institute was about helping professors with patenting and licensing. And in that time they had an exemption in German patent law as a invention in an inventor's law, and I learned that all these guys in that institute have no clue about valuation. So they licensed, they made deals, whatever, but there was no background, no let's say theory, but an economic foundation of IP valuation. I thought this is unbelievable. I mean, it's 18 years ago, but I was really shocked. I mean, in the US, we had these thick books, Smith and Parr and these kind of guys who really tried to explain how the thing works. And here in Europe, nobody took care. So this is unbelievable. But
just like that.
Yeah. It's a negotiation. So and the price is what comes out, and the value and price and costs all is more or less the same. And that was the time. Little anecdote. That was the time when the former head of IP from Daimler. I gave a speech about a presentation about valuation, I think at VPP or something like that, so in front of industry IP guys. And then he said, okay, Alex, thank you very much for this 19 minutes about valuation. Yeah. But I don't think that's anyhow necessary, anyhow relevant, because at the end of the day, the value of a patent is the price which somebody is willing to give me for it. So and in that time, I had no argumentation to counter that. I just heard that as I had the strong feeling that this is rubbish, but I was not able to argument. So when we talk about values, I mean, economic values is an interesting concept, and we have these different influencing factors. So what is your experience? So you wrote something about that in the post, but I mean, typically we have at least three major influencing factors. So we have economic aspects, we have technological aspects, and we have this legal aspect. So how do you deal with that?
That's really good topic. But before answering your question, I want to be provocative to our audience. And always I'm starting with a statement to show the importance of the financial value of the patents. And I say that my statement is patents have no financial value until something. So this statement is missing. And I'm asking to the audience, if you are curious about, if you have anything, any thought about it, please fill the blank. Fill the blank. Patents have no financial value until something, until somebody die, until
it's a riddle.
Crash, until something. What is this? Patents have no financial value until something. This is my statement. But until something. If you don't do something, there is no financial value.
Okay, I have an idea what you mean, but I don't want to spoil your joke. I'm not asked. You asked the audience. So, Mustafa, when we come to these influencing factors about value, how do you deal with that? And also with this terrible complexity. I mean, typically when people think about value and valuation, that after some reasoning, they really collapse under the complexity of the topic. How do you deal with these influencing factors?
Starting to explaining the three types of value of the patents. One is the defensive value, the second one is the monetization value, and the third one is the strategic value. So if I need to argue with the value of the patents, so I'm asking that what are you looking forward to gain with this patent? Defensive value, monetization value, or strategical value? So if you're thinking about these three pillars, so the details are coming, emerged. So for example, for the defensive value, if you're not planning to get direct financial benefit from your patent, the first item is creating a defensive value. As always, all the companies, almost more than 95% are trying to force their patents as a defensive value, which means that creating an exclusivity, the blocking the others, creating, their patents in the market not be infringed by the others, blah blah
So
blah.
basically, it's an insurance, right?
Basic purpose. So they're spending their money for defensive, creating defensive value. This is always the first approach from the companies. But if you are trying to invest on your patents instead of to expend money, instead of to spend the money. So these are the differences: spending the money or investing your money to your patents. So you have to create some monetization value and the strategical value, which means that Ismaila Aliyu has already wrote on the comment commercialization. So the first pillar of the monetization value is the commercialization by yourself. So you can commercialize your product, which one or plenty of the patents are included in the product to protect some of the features. So you can commercialize the product and then you can market it and then sell it and then earn the money. So it means that there is a financial value on that. So if you are commercializing your product and at least one of the patent is included in that product, so we can talk about the value of a patent, financial value of the patent. And then I can simply calculate this financial value of the patent. And the second part is the licensing. If any company, any client is knock your door and then asking what is the conditions of your patents to use as the licensing partner. So, and then we can start to talk about the valuation or value of a patent. And the third one is the litigation. So if there is any evidence of use in the market that somebody is using your patent, that's an aha moment. So you can use your patent as a stick licensing approach, and then you can ask any licensing fee. So we can also start to talk about patent valuation. So this is the most important part, I guess, to start to talk about the patent valuation. Of course, in the third pillar, there is a strategic value, but it's completely different, of course.
I just listen very carefully what you're saying, and I think we should clarify these two terms, which are very close but not identical. It means using the patent, and using the product. So obviously, we have a product with or without a patent. And we should be very precise what we mean with the value of the patent, which is obviously not the value of the product. It's something different. Can you explain that a little bit, how you differentiate that?
So I can prefer to differentiate the value and the price. Because if you are thinking that your patent is valuable, so I can ask lots of questions. And one is starting from the patents are protecting the technologies, right? So I can simply start with the biggest question. This technology, which you protected with a patent application or patent grant, is it solving a problem in any industry, in any application field? So if the answer is yes, and then the second question is coming, do you think that this problem is the real problem? Did you test it? Did you ask? Did you ever test invention market fit? So if you don't do these two important steps, so nobody can convince me there is a value of this patent. So it must solve a real problem in the specific industry, and then this problem must be a real problem, and then your solution must be very effective on a specific problem in the market. So you need to test it and validate it by receiving, information from the market directly. Otherwise, it's hypothetically value. You are assuming that there is a value of your patent because you are assuming that it's solving a problem, but just you are assuming that you didn't validate it. So most of the startups, most of the SMEs, all of the researchers are thinking like that. They're assuming that there is a value of their patent.
Oh, Maria is challenging us, but that's her job. So she asked the following, okay? In your opinion, is the question of value contingent on the number of patents, or to rephrase it, if a company has, let's say, just one patent, can it start speaking about patent value, or is that maybe too early?
Did I understand correctly? What do you mean? Maybe you can simplify it.
So I can only interpret what Maria means. I mean, the question is, so let's say a patent has.
Okay. So you're reading the Maria's question. Okay.
Yeah. Let's say a patent has a 30% chance to get a nullity decision, and to 30% it gets smaller after a nullity suit. We have a certain chance that we cannot detect infringements and so on. So typically you would not rely just on one patent when you want to realize a real exclusivity in the market, which gives you a price premium, for example, for your product, or an additional market share. So the question is, I interpret the question that should a company really rely just on one patent when they hope to create really a business value out of an IP exclusivity?
Yeah, that's a really good question. Normally not. Normally we are suggesting the companies, startups, the SMEs, to build, a group of patents, to create a wall around the product. But it doesn't mean that it must be like that. But this is the best way to create a value in the market, by creating a group of patents to protect different features of a product, creating a wall. But you can also create a value in the market with a one single invention. But of course, you need to think about what is the other criteria that increase the value of this single patent. So one example from my career, we commercialize one patent which is related about a kind of wound care material that can be used for diabetic patients. And then it is only one patent, but protected in 38 countries, very well written claim sets, very strong inventors, very influencing inventors in the market. And then we commercialize this patent by selling this patent to the biggest pharmaceutical company in Turkey. So the product is in the market now, and then protected only on one core patent. It's a core patent, of course, and we are happy that it is on the market. So, which is the very good signal that you can also create a financial value by a single patent in the market. And this success story is also selected by the EPO as one of the best technology commercialization in the Europe.
Yeah, yeah. No, I mean, I'm 100% on your page. We have these cases. It is typically not the recommendation just to trust on one patent, but we have the cases. For example, many years ago, I had the patent for the lotus leaf effect. As a valuation expert, and you don't want to evaluate that because we had so many applications, so many potential markets, and that was unbelievable. And yes, it's just one piece, and it wasn't a patent, it was a PCT application. Yeah? So very tricky case. Yeah, and on the other hand, Apple files 1,400 patents for Shazam. Yeah. So you think this is the most trivial use case you have ever seen? That Shazam is telling you which tune you right now hearing, and they file 1,400 patents. That's unbelievable. Which means, yeah, they want to have a huge exclusivity sphere around any kind of Shazam functionality, and they license it out. Yeah, okay. But we have also cases with just one patent, and this is it. Yeah, and this patent we had this slide to open patent from Apple, for example. So the answer is yes. You can talk about the value, but you should think strategically and should improve your portfolio simply for having a better position in negotiations and whatever.
Exactly. Because after creating a patent portfolio, you need to think about how many of them are based on creating a defensive value, how many of them are based on creating a monetization value, and how many of them based on creating a strategic value. So you mentioned that Apple's portfolio, Samsung's portfolio are really big, huge, giant portfolios. So it means that they are also creating a strategic value unless they are not using in their product, because this is the huge portfolio and their competitors must directly read and analyze all the patents not to infringe any of their the patents. So it means that you are forcing your competitors to spend more time and more resources to be very careful on your patents. So it means that you are forcing them to spend much more R&D resources and money for your competitors.
Yeah, it's a minefield, isn't it?
What?
You create a minefield against your competitors.
Exactly. This is also a minefield metaphor.
So when we talk about the big companies, we talk about successful companies. They focus their IP processes, the R&D processes, pretty much on create valuable patents. So I have, for example, the Signify case in the master program, and Signify is extremely good. So it's Philips lighting branch, and they are so good in detecting valuable use cases for light, for LED light, patent that, license it out. It's an incredible successful IP generation and IP licensing story. So they make billions out of these use case licensing for light. Unbelievable. And when we think about that kind of patents, so obviously they have a huge value. The question is, can you explain a little bit what the, to use your term, what the anatomy is of such a patent?
Yeah, in order to explain this issue, the question is, what is the anatomy of the valuable patent? So I created 10 core factors that needs to be in a patent or in a group of patents. So the one is, as I mentioned, that it must solve a real problem in the market. So this is the first one, because if it doesn't solve any real problem, but if it is granted EP patent, it means that there is no value. There is no financial value. It's not solving anybody's pain. So you cannot say that I have a granted EP patent, but it doesn't solve anything, so it's useless. So the first factor is it must solve a real problem. And then your solution must be, as an invention, your solution must have a product market fit in the market. But it doesn't enough. The third one is the market potential. So the market potential is essential if you are trying to commercialize this patented technology or if you are trying to license it. So because if the market potential means that the market size and the growth rate in particular countries which you are trying to protect your patent. So if you are protect your patent in Germany and France, so you have to be careful about the market potential of your application field in Germany and France. But it is not enough. If you have a market potential in these countries, but if you are not protecting your invention in these countries, so you have nothing. And the next one, enforceable claims. You are solving a problem. You have a good market potential. You have a good solution. There is a invention market fit, but your claims are written as non-enforceable, which means that your competitors can copy your features without infringing you. So you need very good, powerful, enforceable claims in your patent. So this is the next factor.
My recommendation is a wonderful blog post. Maybe Tobias, you can link that also here in the chat, from Stefan Müller. I work with Stefan a lot, and he's patent attorney, and he wrote a wonderful blog post about the question that you can have the situation, for example, in client server situations, that simply this patent cannot be infringed because of the way how the claims are written. Yeah. So a patent is not a description of an invention. A patent is a forbidding right. And when the attorney had not in mind the infringement situation, then you can have exactly that situation. The invention is described, but the patent is, as a forbidding right, completely useless. And insofar, the economic value is nil or even negative because you had all the costs.
Exactly. And what can we say? The another one, maybe we can say that freedom to operate. So holding a patent, it doesn't mean that you are allowed to commercialize this product. So maybe if one or two components of your product are protected by others, by a patent grant, so which means that if you commercialize that, your income will be reduced by paying a royalty to somebody. So it makes your patent the less value. So you have to be sure that other components of your product must not infringe anybody's existing patents. Maybe we can say that strategic licensing potential. So which means that if your target countries are Germany and France, but if you are not protect your invention in this country, so which means that there is no strategic licensing potential in these countries. So you have to be very careful to select your target market, to select before selecting your countries to protect your patent application. So it brings us to the filing strategy. So if you are not sure about selecting your target market as a territory, as a country, so maybe you need to start by applying a PCT application to save some time to decide. If you are unsure, about your target market, start with PCT and then gain 30 months to decide. Don't start with a national patent application because it will give you 12 months to decide. So you have to be rush. So especially for the startups, which they haven't decided about their customer segmentation and their target countries. simply start with the PCT.
Okay.
Also, it brings a kind of protection power. So if it is a single patent, if it is a single invention, but as in my case, we protected our invention in 38 countries, which gives a protection power, globally, very linked with the strategic licensing potential as well, I guess.
I think there's an interesting discussion ongoing in the chat. These guys ignore what we are saying. No, it's a fascinating discussion. It's, I don't know, it's 15 years ago. So people, first of all, people ignore literature. Yeah, you can write whatever you want. The same discussions again and again. So this is one of the reasons why I'm not writing any articles or books anymore. I'm after 18 books, I'm done. Yeah, so I have nothing to say about valuation anymore. And there's a very interesting discussion right now in the chat about the difference between. So they say they are multitasking. There is a wonderful discussion, and it is about the difference between quality and value. Okay, and there is. So I think it's important to understand the difference. And you mentioned it already. Yeah, I just want to clarify it. What you said is, you said when you, for example, cannot commercialize the product which is, for example, patented, well, then you have a problem to create a value for that patent. Yeah, so this is an inference effect. So it can be the best written patent in the world. It has the greatest claims, whatever. Unfortunately, yeah, the economic value cannot be realized. So quality and value are two different things. Yes, typically we would assume that a very valuable patent is also well written, it is enforceable, whatever. Yeah, but we should be careful to simply to say this is identical, and it is not really a prerequisite. There are lousy patents out there which has an extremely high value. Yeah, so this exists. Simply, we have to accept that. I just want. So I'm speaking with the audience. Okay, so sorry for disturbing you. But
No. I was reading as well. For the quality, if you are discussing the quality for the patent value, I think that we need to divide this term into the two parts: quality, quantitative, and objective or subjective. So there are lots of factors that are affecting to the quality, which are quantitative or qualitative, means that objective and subjective. So if you're talking about the number of forward citation of a single patent, which is showing the one indicator of the quality. So which means that this kind of things. So if it is protected in 3 major European countries, which means that it shows the quality, one of the quality metrics of a patent. But the market size, the evidence of use, there are lots of other objective and subjective factors affecting the quality. And Catherine is also agree with me about the PCT. I said that for the startups, it's very suitable for
no,
startups.
I mean, I don't know what people hearing when we try to say something, but I mean, it's obvious you can have a very high quality of a patent, however you define quality, basically legal quality, but simply the invention is lousy. As you said, the invention don't solve any real problem, whatever. So there are so many reasons why quality and value are two different things, and you need quality to create value. I mean, that's a different aspect. Yeah, we should be very, very careful here, and not just making bypasses of thinking precisely. Okay, we have what I would like to ask you in addition is, so we have an ever growing number of patent applications worldwide. We see the digitalization, so we have now 1/3 of all patents are digital patents in Europe, and we see in people inventing like hell. It's unbelievable. And with this IoT, with software, with digitalization, we see a huge amount of patents around the globe, and it is obviously so. There's a very specific case which makes it especially complex, which means companies have, for example, a non-digital legacy. Yeah, so they have a traditional product, and then so I had the showcase with the Thermomix, and the Thermomix with the fifth generation of the Thermomix became digital. So it became a part of a digital ecosystem. It became a downloadable recipes, whatever. And with that move, the company Vorwerk had then the problem to take care about tens of thousands of patents from competitors which they have never heard about, because downloading data for a machine which steers a machine is, I mean, this is nothing new. Yeah, and it wasn't new 10 years ago. And so it is extremely hard for them to follow competitors, even to define who are competitors. And so how do you think, how can patent information help, and how can we make strategic use of this kind of this class of information?
Yeah, it's a kind of competitive intelligence, maybe we can say as a term. But I realize that most of the companies are not aware the power of patent information to create their competitive advantage, or to be aware of activities of their competitors. But if they are aware, like the biggest companies approaching me, we are using patent monitoring. We are monitoring our competitors' patent every month, but our engineers are not reading these patents. We are sending them every month, but our engineers are not reading, because I'm asking that why? Because the number of the patents that we are sending is too much. And it is the same that you indicated. And the patent applications are, the booming, and lots of patents are filed, and it's unbelievable how these companies can follow the activities of their competitors. So in the artificial intelligence era, so we need some new kind of solutions to solve this problem, of course. So, if you are monitoring your competitors' patents every month, bi-weekly, so you will receive maybe hundreds or thousands patents, and there is no time to read all of them. So the AI solutions can also help the companies to summarize, to indicate the focus of a single patent or group of patents, and then they can simply understand what are these patents are about. And
so what comes into my mind is that we come to a situation where I'm working a lot with Bastian Best, and Bastian makes this robot drafting courses. So we use, obviously, I mean, Sebastian Gödel said it very much. I like this site. I cite him every day. So the IP world is a text production world. It's a text interpretation world. So how can you imagine that large language models have nothing to do with IP? I mean, that's ridiculous. And we come to a situation where AI is writing the patents, then AI makes the search, and then AI is analyzing the patent. So we are not needed anymore.
Now the final decisions so must be given by the experts as well. For now.
Okay, so your recommendation is we should. So I'm very happy. I have next week. I'm talk about an AI tool, and I'm working with some service providers which have AI tools with which they're extremely powerful to analyze IP, and meanwhile these. The strange characteristic of some LLMs under some conditions that they fantasize that is under control. So my understanding, and it works simply extremely efficient. So what is your experience with that? So do you have a specific tool? Do you work with different tools? Do you have your own tool? How are you working with that?
Yeah, in terms of the use of AI in the patent business, so I created around 100 use cases that can be possible to use AI for the patent businesses. So I'm giving this workshops and trainings my clients as well. But of course, if you are using the generalized trained tools like ChatGPT and other tools, these are trained with the general information, but the patent jargon, the patent terminology is completely different. So as I see that our colleagues from all around the world are trying to build some specialized fine-tuned databases, tools that can be helpful for the patent experts. But my experience is it's also custom GPTs can be helpful if you can train these custom GPTs on the purpose of what you are trying to do. For example, if you are trying to compare some of the claims of two patents, you can do it simply with an AI tool, free of charge AI tools. But if you are trying to draft a patent, so it's the game is changing now. If you are talking about the patent drafting, I totally agree with the best and best to do it with the local, your local server. So you need to download some language models to your computer to swim in a safe zones in terms of the confidentiality.
I mean, from my understanding, Mustafa, this is the future. So we will run on our own chips, our own models, and the next level, the next mobile phones will simply have that in it. So you don't want to use the cloud for that. So this is just a situation at the moment. It's a kind of bridging technology. So in the future, we run the things on, because I want to have an individualized trained model for me, so what I'm doing, and so this is I guess the future logic.
In terms of basically I created myself as a custom GPT, myself, my second brain. So
yes,
it is thinking like me because I trained with my own data, my own articles, my own training documents. It's all trained with my thinking way. So it can also simply write anything like me. So why this happens to patent business? But I agree with that. In the near future, we will buy our own chips, all machines at home, and then we will train our own language models.
Exactly. I mean that's only logic. Yeah. And then we don't have these cloud computing discussion, and I guess that's just at the moment a problem. Okay, so we're running out of time. So there is maybe one question. Maybe you have a short answer to that. Anna had a very good question. Or let's say I read the question, and then in the after show party on LinkedIn, Mustafa, it would be great when you could answer to her. She asked how you can minimize the risk of contamination of R&D activities of competitor IP monitoring. So I guess it's related to willful infringement and the problems with that. And when you have money, so I know companies in the US, they don't make any monitoring anymore, just to avoid exactly that. So that would be great when you could answer to her. This is our suggestion. So we will be available on LinkedIn over the next time, and we will try to answer to your questions. So thank you very much. Thank you, Mustafa, for being here with us. And to the audience, thank you very much for your attention and for your time. And I promise we will be back. Bye-bye. Thank you very much.
Thank you so much.